Hi, everyone. Thank you so much for joining us today for our webinar, COVID-19 Insurance and Risk Mitigation for Your Association. We have muted all of the participant devices to eliminate the background noise so everyone can hear clearly. And the view options on your screen can be adjusted to display all panelists. All you have to do is navigate to the view options on the toolbar and select the side-by-side option for optimal view. All right. Special thank you to Global Pro Recovery, the Water Restoration Group, and Siegfried Rivera and Willis Tara Watson. These are the companies where our panelists come from today, and we'll learn a little bit about them in a minute. A note about questions. Feel free to submit your questions at any time by navigating to the Q&A option on the toolbar. Here we have a screenshot of the button that you should press, as well as the dialogue box that will open. So we're going to do our best to answer all of the questions live and the questions that you submitted prior during registration. We might not get to all of them, but if you email us at info@caslagroup.com, we will get back to you. We've done a great job at getting back to everyone within 24 hours. So I assure you that your answers somehow will get responded to, okay? So let's go ahead and begin. Let's start with a little COVID-19 update. So we have about 1.9 million confirmed cases, and 453 of them have recovered, which is good news. In the U.S., we have about 682,000. A note regarding the stimulus checks, we've had the first wave being distributed. If you filed a 2018 or 2019 tax return, these will be deposited directly to your bank account. If you have more questions or if you have a particular situation, we recommend you go to irs.gov/coronavirus/economic impact payment information. It's this link down here, and you'll find all sorts of information regarding the stimulus package. In addition, the CDC has recommended for all of us to wear face masks or face covers, regardless if it's a medical one or just a cloth covering. If you're going to the supermarket or you're standing in line anywhere, CDC has recommended for us to cover our faces and our nose. In our mouths, excuse me. So this next slide here is actually a screenshot. We took this at about 9:30 this morning. This is an internal dashboard CASA Group has. This is how we're monitoring our emergency response operations. So as you can see, we have about 21,000 cases in Florida alone. Concentration we're seeing in the East Coast areas and the West Coast as well, mainly the Tri-Counties. Over on your upper right-hand side, what we're seeing is we're making sure that we're monitoring, that we're having the proper communications with all of our sites, that we're tracking and inventorying their supplies so that we can fill that gap should supplies run low. And this is just what we're doing. We are an essential business, so we are open and we are on the grid working hard for our associations. So let's get into it, right? Let's talk a little bit about our experts. As you know, I'm Jessica. I'll be moderating today, and I'm going to give everyone an opportunity to speak as to who they are and what we're going to be talking about today. So go ahead and take it away, guys.
I guess
Roberto,
I can.
would you like to start?
Yeah, sure. I'll start. My name's Henry Dow. I'm with the Water Restoration Group. You know, we do obviously what the name states, water restoration, but we're also doing mold and asbestos. So we're very familiar with cleanings that need environmental controls. So as we find ourselves in this situation, we are helping associations with that type of cleaning. You know, different associations are requesting different things based on what they decide they want to do and how they want to handle stuff. So we're doing cleaning to prevent, to disinfect, and I'll answer your questions as we go on. I'll let other people introduce themselves. Thank you.
I'll go next. You guys hear me? Well, yeah. Dan Odessa, Global Pro. We're a company that focuses on insurance services. We represent more than 1,000 community associations in the United States and helping them manage risk to recovery. Most people know us as an adjuster that we help our clients in the time of their need when they have a loss, recover from the loss and damage. And we've been obviously very busy since the pandemic took hold of our economy and our society here, and working closely with management companies, building engineers, facility managers, and boards to understand their rights and obligations under insurance policies and how they can recover from these damages. And I want to thank Castle Group for the opportunity to speak with all of our attendees.
Sean?
Okay, thank you. So my name is Sean Gabay with Willis Towers Watson. I lead the condominium practice. Willis Towers Watson is a leading global risk consulting and insurance brokerage. We are based all over the world, 140 countries, but we do have a specialized focus here in South Florida for condominium associations, and you know, from beginning to end, kind of like what Dan said, but from the quoting process through to claims, and also working with these other professionals here on the panel. So thank you for having me.
And my name is Roberto Blanche. I am a shareholder with the law firm of Siegfried Rivera. My practice is focused exclusively on representing community associations, including homeowner associations, condominium associations, and a handful of co-ops, which we have a few in South Florida. Our experience, notwithstanding the COVID, does revolve around assisting community associations with every single need they may have, from the very mundane to the extraordinary issues that arise in community associations. And I don't believe that this pandemic is any exception. We've been busier than ever before, thank God. But frankly, trying to assist our clients navigate through this dilemma has proven to be quite interesting and quite an educational experience. And if anybody would like to, on our website, siegfriedrivera.com, there's a red banner link that can take you to a lot of the resources, governor orders and mayoral and city orders as well that have been issued, as well as other material that may prove to be helpful to anyone who is attending this webinar. And it's a pleasure to be part of this panel, a very prestigious panel. Thank you, Jessica, and thank you, Castle, for the invite.
Yes, absolutely. Okay, thank you, guys. So what we'll be discussing today, as it relates to your association, insurance, risk mitigation, liability. We'll talk about association losses, confirmed cases, your amenities. I know that's a very hot topic. And then we have a lot of other discussion points that were given to us during registration that we'll touch upon today. So let's begin. Sean, I want to give this question to you. Why don't you start us off with the potential association losses that exist with COVID-19?
Great question, and it's actually a great starting point. So for condominium associations, there's first-party exposures, and there's also third-party exposures. So first-party exposures is anything that the association is owns or is on the hook for as far as expenses for their own property. So, you know, one potential exposure is loss of business income. You know, if the association has a component of, you know, a hotel component or some revenue income component, which most associations don't, but if you do, that is one exposure. Also, another exposure, first party, is your cleanup or remediation cost that you might have if you were to have a confirmed case in the building. And then on third party coverage or exposure, you have if you're named in a lawsuit, if someone sues the board or the association because of any reason, so that's a third party exposure. And the last one I can think of is if you're a self-managed building, you know, the payroll and more so, you know, the CARES Act, which we'll get into later, but but potentially that type of exposure as well.
Great, thank you. Dan, would you like to add anything?
Yeah, I think there's been a lot of confusing information coming from the insurance industry, and sorting through the representations made by insurance lobbyist groups, special interest groups at large, and trying to determine fact from fiction. And I think Sean paints a pretty good picture about how there's so many different angles and issues that we need to look at from the insurance perspective. It's not a one size fits all, which was the way in which it was immediately painted by the industry. You saw a lot of lobbyist groups come out, issue actually written notices, which we've been collecting regarding no coverage as it relates to virus. You recently had President Trump come out and discuss and make statements regarding income coverage and how he's never found in a policy the words global pandemic. So you've seen legislative action. You've seen a lot of different confusing remarks by various different politicians and industry experts. So it's very important that you understand what your policy actually includes, and that if someone that is an expert in insurance has not actually looked at it, whether that's they trusted a broker or someone like ourselves, there's really no way of knowing. Just because your insurance company denies your claims or tells you that you don't have coverage, as some restaurateurs have found, it does not mean it should not be paid. We see denied claims all the time that are reversed and paid without the need for litigation. It is a time to consult with your attorney about your third-party obligations to unit owners or vendors, but it's also a time for you to be looking out for your own vested interest in what you're paying for in your insurance, and making sure that you understand the nuances of your policy as it relates to the jurisdiction when you fall, because Broward is very different than Miami-Dade, and then the cities within each of those counties are very different as well. They all took different approaches to restrictions and regulations regarding access to properties and things like that. So all of that becomes part of the claims investigation. So important that you take steps to do that. And also that you hire experts like WRG, Water Restoration Group, to access your property and to provide you proper mitigation protocols. Because I'm sure Sean would agree with me, and I'm sure Roberto, making sure that you have someone that's licensed and educated in how to abate this issue is going to be paramount to anything regarding any sort of insurance or recovery.
Excellent. Roberto, do you want to expand or add on any of the points that the gentleman made?
You're on mute.
We've muted Roberto. No.
Familiarizing yourself with the policies and with the professionals, as both Sean and Daniel mentioned, I think is the critical issue here. And again, recognizing that, relatively speaking, these are extremely uncharted waters, and while it may be of no comfort for many of the participants, we are trying to do, all of us as professionals, the best we can to interpret the laws, interpret the policies, and I have a good feeling that a lot of us are going to be on the winning side of the arguments. But if push came to shove and we had to get involved in some type of procedure to debate and argue, whether it be filing a court action or an arbitration, some of us may be making interesting law going forward.
Great, thank you. So Dan, going back a little bit, you brought up a great point regarding remediation. So Henry, tell us a little bit about this process, right? What kind of calls are you getting from the associations for cleanup? What are some of the costs involved?
Okay, it's going to depend how the association wants to handle it. I've seen everything. We've had associations that want to handle it as if somebody's that is infected is there all the time. So we've had them say, come in here, install equipment and leave it here in all the hallways for, we'll tell you when to come pick it up. So we've had people go to that extreme, and also having us wipe down their common areas constantly. We have other people who are not taking it to that extreme. In other words, they're just having their in-house staff do regular cleaning with household products, which is acceptable. If you go to the CDC website, they'll show you a list of what products are acceptable. So what do? I mean, we follow the CDC and we follow OSHA. So CDC tells us, roughly, what kind of products can we use, what's acceptable to prevent this or to clean or to disinfect. And then OSHA obviously relates that to the safety of the people doing the work. So we have to use gloves, we have to use goggles, depending on the product, what do you have to use? So it really depends on the association. And then if you have someone, confirmed infected in a unit, then that's a legal situation, I guess you can call it, determining if they're allowed to stay in that unit or not. But when they are quarantined in the unit, normally what we've seen the buildings want us to do is stay on top of that hallway, cleaning that hallway, and then the association makes sure whoever's catering to that person is being extremely careful. So again, it's going to depend on the association and to what extreme you want to take it, and obviously, there's budgetary issues that need to be discussed. But on an average, you're looking at 45 cents, 50 cents a square foot to clean the areas, to disinfect.
Okay, great, thank you. So let's get into what happens if there's a confirmed case, because I think that a lot of our questions will be answered there. So we have a confirmed case in an association, and you incur expenses like Henry talked about, maybe some remediation procedure that went on, products, whatever it is. So what policies could potentially pay, Sean?
Great question. So there are a few different policies that could potentially pay, but it's important that not every policy is written the same way. Every policy has different variations. So you have to make sure that each one of them is reviewed by a professional, to determine the extent, if there is any coverage for COVID-19. And also it depends on the jurisdiction and circumstances. So, but broad topic, what policies would pay? We're looking at potentially the property policy. Okay. Also, there's a pollution or an environmental policy that could potentially pay. And then there's always manuscript policies. But as far as the condominium association world, those are the two policies that could potentially afford coverage. There are some roadblocks, which we'll discuss. There are some roadblocks, but those are the two policies.
And I think building on those statements by Sean is that it's sometimes not what it says it will pay for as much as it is what it doesn't exclude. So a lot of us have the special forms, and I'm sure anyone who's been tracking the media, there's been discussions about different types of insurance policy forms, and I think more people know about those forms, and there's that lingo now more than ever. And there's different special forms that are all risk insurance, quote unquote. And those underlying forms do provide coverage, but through endorsement, the insurance industry has at times attempted to exclude or limit coverage for certain things, such as virus. But the language that's contained within those endorsements in your underlying policy may be in conflict or may be ambiguous and therefore construed to your benefit, meaning you have coverage. So again, it's very important that you, as far as if you have a confirmed case, that you do give prompt notice of your loss. But when giving notice of that claim, as we tell our property management companies and associations at large, as we're doing a lot of education, be careful with the language that you use in reporting of that claim. You are not an expert in virus. You're not an expert in mitigation. You're not a lawyer. Be it as it is that you took steps to remediate damage on site. Beyond that, you're not sure about the details regarding it. As soon as you obtain your documentation information from your contractor, such as WRG, you go ahead and promptly submit that to the insurer. But making sure that the language on that stuff is consistent and that the date of the reporting is what's inside your incident reports, whatever else, is really important to your claims process. And again, I think a lot of this information regarding claims and whether or not it's going to be covered or not paid is yet to be seen. I think it's rely largely on a number of lawsuits that have been already filed, or on a state or federal level, some laws that may come down clarifying the intent of these policies as it was known to the legislators when they approved them. A lot of legislating bodies are saying that when they approve these forms, they do not understand the intent of them to exclude an event such as this. And that's very important and material to in which you make your claim and how it's reported. So making sure, though, that you gather all the facts before you call your insurance company is also important. And if you have any questions, that you do consult with someone knowledgeable in this practice area. It is not uncharted territory for an insurance company to pay for virus-related damages. We handle claims just as recent as Zika with success. So keep that in mind, that it's not a one-size-fits-all, and you need to take steps to make sure that you consult with experts to walk you through the process, make sure you're saying the right thing.
Great. Is there any wording that we should be careful about that will preclude coverage?
Yeah, we've been educating our clients as relates to it. It's property damage. We have seen several executive emergency orders entered in the South Florida area that confirm that virus does cause physical damage due to its proclivity to attach to surfaces. That's the actual quoted verbiage being used. You simply have property damage. Being general is okay, so as long as you've given the proper notice of it. When actually making for your damage, you need to provide additional details regarding what you are claiming, unit price and quantity, a brief description of it. And at that point that you're making that claim, it's important that you consult with someone's lawyer, whether it's your broker or someone such as ourselves, to ensure that you're not prejudicing yourself in any way. Again, it's a very complex issue, but it's really no different than what we're dealing right now with water claims. If you say the wrong thing or insinuate that something has been long-term or from a construction-related issue or whatever else, a lot of insurance companies are taking the approach that they're not covered and creating various different hurdles. So language now, though, is more important, more so than ever before.
And just
Okay.
to add, so I mentioned before there were two hurdles, and the first one we sort of discussed, which is that direct physical damage wording. And as Dan mentioned, very early on, the insurance carriers were taking the position that COVID-19 was not construed as direct physical damage, which is what triggers the property policy. Okay, so there's been emergency orders, like Dan mentioned. Here's one from Broward, which does mention that COVID-19 is direct physical damage. Our global claims team is actually taking the position that COVID-19, if you do have a confirmed case, would be construed as direct physical damage. So that would be hurdle number one. Then hurdle number two is that exclusionary wording in there. And again, every policy is different, but just to give you a couple examples, if you have a communicable disease exclusion, that could pose some challenges. If there's a virus or pandemic exclusion, and we'll talk about more of those, but those are the two hurdles. The first one, we believe that can be overcome. So.
Great. So I have a couple of questions here from the audience. I'd like to answer a couple of them. This one's for you, Sean. So we had to do a complete fogging and cleaning after the elections, which we were not allowed to cancel. We spent $10,000. Would that fall under the first exposure? We had cases of COVID-19 after the elections that cannot link the two definitively. Sorry. What are your thoughts on that, Sean?
So the cleanup costs, if your policy were to afford coverage and you can get over the two hurdles, the policy that would pay would be that first party coverage. I believe you're referring to first party versus third party. So since it's an association expense for the cleanup and mitigation, that would fall under first party coverage, which would either be a property policy, if you can get over the two hurdles, or potentially a pollution or environmental policy, which those policies are unique, where they would pay for not only the remediation, but any liability that you may have, that comes about because of COVID.
Interesting.
Yeah, I think a lot of people have seen the virus or bacteria exclusion endorsement in their policy through the more well-known insurance and companies for community associations down here. A lot of their policy forms do include that. There's question as to whether or not that would be that second hurdle that Sean spoke about and exclude that coverage. Under the pollution provision, pollution endorsement of a policy or language, in some jurisdictions in Florida, we found through our research is that it would not be considered contamination and therefore would not be excluded, and therefore you would have coverage. Because it would not be part of that definition. It's a very, again, complicated and technical argument and issue. And that's what we're talking about here. Something unprecedented situation to the point where you even have the President of the United States commenting regarding insurance coverage and using words like global pandemic. That's what makes that second hurdle so complicated, is that there's been a lot of assumptions as to whether or not that virus or bacteria endorsement would in fact exclude coverage or not.
Just to add to that the pollution endorsement, I was referring to a standalone pollution policy. So, you know, there's two different types of policies, but what Dan was referring to is an endorsement within a property policy. But yes, our position is we don't see that, and depending on the wording, obviously, depends on your policy. Every policy is constructed differently, but the pollution exclusion, that is geared towards something else. You know.
Great, thank you. So I have a question regarding the board's responsibility, right? Roberto, can you talk a little bit about your recommendation, right, for the board, their responsibilities, and if there's any personal liability that can fall on them or the association? You know, I have questions about people implementing best practices, but the residents aren't necessarily following the rules. What can they do to enforce the rules? If someone gets contaminated, are they liable? Can they get sued? These are the kinds of questions that are coming up for us. What are your thoughts on that?
Well, you know, we have been confronted with a series of questions, not just the one that you presented, but in the weeks that have transpired since this pandemic affected our communities. Within community associations, we have had situations that include folks that have tested positive voluntarily and stay in quarantine and manage to stay quarantined and walk around and use whatever facilities it can, elevators, stairwells, doors, entrance lobbies, etc. A lot of this poses various questions to community association board members and managers as to what can and what should we do. On the one hand, we as board members and as managers have an obligation to take reasonable measures and reasonable action to protect the health, safety, and welfare and well-being of the members within our community. And so if you've got 99% of condominium associations closing their gyms in compliance with the recommendations from the CDC and with mayors, emergency orders and governmental orders that are issued, and you are in a community association that refuses to close your gym, I think you've got a problem. But for the most part, if not all entirely, my clients and those associations that I've come into contact with have advised me that they have complied with the recommendations to close discretionary, areas of discretionary use of common elements such as the gyms, the pools, the social rooms, etc., and also try to promote measures to minimize the number of, let's call them non-essential, right? That term essential individuals is also very loosely worded, and I don't know if anybody really has a handle on who is essential and who isn't. But we do see associations that have gone as far as restricting guests from coming on to the property, all vendors, housekeepers, and yet others try to define a very close sphere of who can and is allowed to access units. And they're trying to balance legal issues such as the statutory right that an owner has to have their guests and their family and their invitees come to their units. Of course, right? We can still gather in groups of 10 or less individuals, right? 6 feet apart is what they continue to profess. So I guess that's acceptable, but condos are going beyond that. Whether that is permissible, whether that is going to be upheld as within the discretion of what condos can do in these types of emergencies remains to be seen. I would rather be on that side of the argument. I would rather be with those associations that have acted overly cautious than those that have not taken enough measures, those that have not closed their gyms and those that have not closed their pools and continue to allow a more free flow of folks that may be, carrying this virus. Those are the ones that I think might be exposed to some liability. But those that have acted what we in this new normal are considering to be reasonable and promoting this social distancing and staying at home, I think are the ones that are going to be protected.
Great. Thank you. Thank you for that. So we have a couple of more questions that came in here. As far as a resident with corona is concerned, if they do not disclose it, you are not entitled to know, as I understand it. So I think what are the HIPAA regulations regarding a confirmed case?
Well, it's not so much about HIPAA. I don't believe that we are subject to that, but we are subject to certain state privacy laws. So we are, as association stakeholders, somewhat limited as to what we can insist upon learning. And I think more delicately than that, what we do with information when we do obtain it. I believe that we need to create an environment where residents are encouraged to disclose to associations, whether to their management, to their boards, whether they have been exposed, and definitely whether they have tested positive, so that the association's management and directors can be in a position to act accordingly. But there's no way you can force anybody to disclose it. So now you start having to wrestle with issues of psychology. Do we create an environment that encourages folks to disclose? When we have this information, if we publish it throughout the building and say, Susie Jones of Unit 504 has tested positive, are we now setting a policy where everyone else that might test positive or be exhibiting symptoms may now be discouraged from disclosing? And so these are the psychological balancing tests that managers and board members need to start taking into account, and also speaking with the lawyers, because human nature within your communities is going to be such that everyone is going to now storm the manager, storm the board members, and insist upon knowing who is the positive case, what unit are they in, what floor are they in, what elevators did they use the laundry rooms, did they use the mail room? And management and board members are going to have to treat those issues very delicately. And I think they're going to have to work hand in hand with their lawyers to identify what best practices can be deployed in this new world that we're living in as far as disclosing information.
Great point. Well, so I'm getting some questions here on amenities and cleaning and things like that. So let's move on to our second topic. which is the ins and outs of amenities during this new global reality that we're facing. So what do you recommend is the proper protocol for amenities, Roberto? And I want to add that for Dan, Henry, and Sean, I want to add to that. What can you do so that if you do file an insurance claim, these procedures and these precautionary protocols that you're doing allow you to get paid out?
Well, I'll just take a quick stab at this. I believe that you, again, do as an association what you easily and quickly can do. It's very quick. It's very easy to close the gym. It's very quick and easy to close the social rooms. A lot of associations have taken the emergency orders and interpret them to suggest that pools need to be closed and use of pools need to be restricted. Other associations have interpreted that provision in other ways and have not closed their pools. But by virtue of closing the use of all of these facilities, they are now minimizing the ability that there may be spread through these facilities. If you are going to maintain certain facilities open or certain items within your buildings open, then now you've got to ask yourself, what can we do as an association within reason to wipe down those surfaces, to clean those surfaces? Do we have the resources to do that? I was on a call today with a community association that is indicating and projecting that their janitorial bills may increase 30 to 40% as a result of these issues. So, you know, these are all questions boards and managers are going to have to handle, but do as much as you can within reason to keep things limited as far as access, and so clean and wipe down we can on a daily basis. And then, of course, when there is a known infection, then call the folks like Henry to come over and do a more thorough cleaning of the areas impacted.
Sean and Dan, do you want to add to that?
Yeah, in regards to the proper protocol and procedures for amenities and shutting down, you know, the pool or the clubhouse and following the emergency orders, our recommendation is to create as little liability or exposure to the association as possible. You know, does that mean that you know you're not going to be sued? That in this day and age, you know, there's always a creative attorney out there that comes up with some case that, you know, that the association do A, B, and C. So that's not gonna avoid potential lawsuits, but by following the proper protocols, following the proper orders, and minimizing or reducing the exposure that the association has, that's recommended.
So I have a particular question here. Someone asked if you, if you do keep your pool open, but you spread your chairs, right, to promote social distancing, or if maybe you put a sign that says use at your own risk. I mean, is this okay? Is the association still exposed to liability? What are your thoughts on that?
In regards to a sign that says swim at your own risk or use at your own risk, you know, the insurance carriers, specifically general liability carriers, they want to see that signage regardless if there's COVID or not. So I would always recommend having those signs, and typically we see insurance carriers during a walkthrough when they provide the report. That is one of the recommendations if you don't have one. But as far as keeping the pool open and you know, basically having the chairs or the lounge chairs separated for social distancing. I mean, there have been orders that different municipalities, Dade, Broward, Palm Beach, have come out as far as closing these amenities. But let's just say those weren't ordered. Our recommendation is to try to minimize the exposure of the association as much as possible. Don't leave a loophole or a window open for a creative attorney to sue the association. Because remember, there's if you receive a lawsuit, that's third party coverage. So we talked about first party, now third party coverage. In third party coverage, you're talking about your general liability policy and your D&O policies. D&O policies, the vast majority, if not all D&O policies, exclude coverage for bodily injury. So if someone contracts COVID-19 and they sue because the association or the board didn't do A, B, and C, that is bodily injury. So that eliminates the directors and officers policy. You have your general liability policy, and your general liability policy has a few speed bumps or hurdles, just like the property policy. And there's some exclusionary wording in there. We have seen communicable disease exclusions on a general liability policy. Most of our policies with our condominiums do not have those exclusions, but we have seen them.
And I would add that, because the virus can't cause physical damage to a property, it's somewhat like, consider it water, which you can actually see, and you have that obligation to stop the water from continuing to pour through the building. So to the extent that you're under an order and obligation to mitigate your damages, you need to mitigate. So to taking those steps, either on a first party or third party side, is paramount to any sort of coverage, whether it's specific or vague or in dispute. It doesn't matter. You need to make sure that you are following the proper protocols, giving the proper notices to it, and taking every step you possibly can to mitigate the spread of the issue or the extent of damage, the scope of the damage from getting larger or bigger or more significant.
So let me ask you this. Are there any rebate or discounts on insurance policies for the association since all of the common areas are closed? Is there anything like that exists?
So that's a good question, and most likely not. Unfortunately not. And when underwriters and actuaries price insurance policies, they take into account the exposures. Take for example your property policy. Property policy for a condominium association is typically the single largest premium policy. So the underwriters take the modeling into consideration, for maximum probable loss, and there's all these formulas that they implement to price the property policy for associations. And what they take into consideration is, hurricane and the distance to the coast and your roof age and if you have impact windows or not, but they're pricing it based off of the exposure of what they believe in their portfolio for exposures like hurricanes and fires and water damage. By closing amenities, for property policy, that doesn't negate exposures like a hurricane, because we still have a hurricane season around the corner. And conversely, actually, we're seeing, there was an article that the surface temperature waters are 4 degrees warmer than average. So they're anticipating a more than active hurricane season. So you have policies, like your flood and your property that have nothing to do with closing amenities. The policies that have a connection or would tie to your amenities would be like your general liability policy, slip and falls in those areas. But even though those are closed, I know some associations are not. There's still people on the deck, going from one building to the next. If depending on the setup of the building, it's not, completely off limits. Yes, nobody can go in the pool, but so it depends on per association. But no, unfortunately, as far as premium discounts, we're not seeing carriers relief there.
You are seeing auto insurers step up, and apparently people are driving less miles. So if you haven't gotten notice from your auto insurer on your personal side, that's where we're seeing it. But I think the point that Sean made is well received, but also a bit controversial in the fact that you are not using it. So there are the lack of use, like with your auto. How does that contribute to an increased risk, and why do I still need that insurance? I had one condominium association want to know if they can cancel certain insurance in order to save money right now because they're not using certain areas. But obviously that would fall under some other type of legal obligation to make sure that you have your entirety of your property insured. But also begs the question, if they didn't insure us for this type of loss and we don't have use of those spaces anymore, then and they're receiving money from it, how does that equate to any sort of necessary coverage, or how do I derive any sort of benefit or measurable transfer of risk for that premium? So I think it's an interesting nuance and issue that I think some auto insurance are looking closer at.
Great. Yeah, so this whole thing with amenities, we're also seeing, I mean, I have a great question here. The boards are receiving a lot of pressure to reopen the amenities, right? Because they are taking the proper precautions. So Roberto, if let's say that the residents demand that the reduction of membership dues, that they reduce the membership dues because they can't use the common areas. I mean, can they do that? Is that something that they should do? I mean, what basis does that have?
You know, unit owners need to recognize that there is no provision that justifies the reduction in assessment payments or the return of assessments paid by owners as a result of their inability to use amenities. You know, they're still going to have to pay their assessments. The assessments are based upon what the association's budget is. And given that the association had to close its gym or its pool, you know, there may be some reductions in those expenses. But as I indicated earlier, your housekeeping and janitorial expenses may have gone up because of this. And so at the end of the day, the association's managers and board are going to have to look at their budgets, see what went up, what went down, and balance it out. The owners are going to have to pay for whatever the monetary obligations of the association was or were, and whether or not an owner or a tenant was able to use the pool or the gym or the card room or the business center is not going to entitle them or justify their reduction in the payment of assessments. Now, with that said, if hypothetically speaking, as a result of not running the pool heater in the pool during all this time, we've reduced our gas bill significantly, and now at the end of the year, we have a net surplus, well then guess what? The association can use that, carry it forward into the next year's budget cycle, and that might assist in reducing next year's assessments. But owners, you know, owners need to be very sensitive to this issue, and managers, I can almost guarantee, and those that are on the line may attest to the fact that managers are looking very downstream on what may lie ahead. They're projecting reductions in people's ability to pay assessments or increase in people's inability to pay assessments. And so they're projecting delinquencies on the rise. Associations are lowering the discretionary items. You know, the flower arrangements in your lobby might be sacrificed, and maybe some discretionary or additional labor in your building might be reduced in an effort to minimize what your budgetary expenses are, taking into account that we might be getting an increase in delinquencies resulting from this down the road. So we've got to be mindful of that from a long term and not be short-sighted and want to give all this relief to owners. And I'm not going to dive into it at this moment, given that we may not have enough time. But another question that's come up a lot is what to do once we start having these delinquencies. You know, what do we forgive? Do we give people an ability to not pay assessments if they demonstrate an inability to do so? So these circumstances have presented a great amount of new issues, or some old issues now have reared their ugly heads again. If we remember back in 07, 08, when we had our last economic issue with the real estate market and what that did to assessments and collections for associations. So we're bracing for a lot of that in the months to come.
Wow, great. Thank you for that. So I have an influx of cleaning questions, and actually it's our next topic when it comes to, disinfecting and cleaning the amenities. Henry, I'd like for you to start, though, with a bit of an intro. Maybe you can go over some of the CDC recommendations and comments regarding disinfecting, and I think that will answer some of our attendees' questions here that just came in.
Yeah, again, it's each association is taking it to different levels, but in reality, if you look at the CDC website, cleaning can be done just basic cleaning, routine cleaning, all the high touch surfaces, wipe down, you use the EPA approved products. Many household products are approved to be used doing this. I think the biggest issue in doing this in-house is that you need to make sure you spend a little time training or having someone train your in-house staff, because I think that's where the issues could come in. Because cleaning is one thing, another thing is protecting your employees. So if you have them doing the cleaning in-house, but you haven't trained them, you haven't told them these are the risks, this is the personal protective equipment you need to use, not just because of the virus, but because of what product you're using. Each product's going to tell you what you need to use to apply it. So again, if you look at the CDC website, it's got a specific area that tells you how do we clean, how do we disinfect, and this is what can be used. I mean, they even talk about soap and water. It's just basic wipe down. But I think the most important part of the cleaning is the training. So don't just instruct your staff, hey, we're going to do all of this in-house. Go ahead and just do whatever you were doing and just keep wiping down. I would take it a little bit more serious than that. This is a clean that could come back to haunt you, with lawsuits, as Robert had said. So you just got to make sure that everybody's trained and that you don't find yourself in a tough situation because you didn't train the people to do the work. But it's not something that's rocket science. There are like I said, there are associations that want more than just the cleaning. They want the equipment running in there, cleaning the air. They want us, spraying and fogging the air. That's just up to each association. But the honest answer is, based on the CDC, you can do routine cleaning. You can use your in-house staff. Just spend some time training.
So would you say that if you have a confirmed case, the cleaning would be more rigorous, but other than that, and maybe hire a company like yours, but then if there aren't any confirmed cases that you know of, that you can do a lot of it in-house, a lot of the cleaning in-house with the CDC recommendations?
Correct, but I think it's safe to assume for the most part, I mean, because confirmed cases are, the ones you know about, obviously, but there's so many of them that you don't know about, so
right.
It's safe to assume there's people walking around there that have the virus. So, again, it's a budget thing. You can't spend a ton of money every time someone comes in infected with a virus. Again, if you're an association that has that kind of pocket, it's a different story. But every time someone confirms that they have the virus and then you're doing a very rigorous cleaning, it's going to get very expensive. So it's kind of a balancing act that you have to do. But once again, I mean, even if you look at the CDC website and you read about confirmed cases, if it's in a unit, you can contain that. But what about when you're talking about all these common areas? What when you're talking about the lobby? These are areas you can't just close down. So
I think that's part of the insurance coverage conundrum that we're dealing with currently, because as you see in some countries like Italy and Korea and China, you see the suited up hazmat gear and people fumigating the streets at large. And that's actually referenced in many of the lawsuits being filed about how, in order to properly eradicate this issue, you need to take those types of measures. And if that's what I have to do outside the property, what am I doing on the inside of the property? And is the threat of the virus in the area sufficient to establish physical damage or loss at the property? and do I have coverage to go ahead and clean my property? Without actually having a confirmed resident on site with the virus. And that is certainly a coverage conundrum right now, and a question that's posed to various different jurisdictions and courts at large. So to Henry's point, it's, if you have the money, you go ahead and do a routine cleaning, and then you hit it real heavy if you actually have a confirmed case. But again, that racks up time and expense, and material is pretty significant. And there's a huge list on the CDC website of things that you can use, everything from viricides to household products, as Henry mentioned. So it just depends on, and some of the viricide or some of the chemicals they put on there, if you read some of the material safety data sheets, I don't know which one's more harmful, the solution or the actual virus itself. It almost seems you have to buy twice as much gear in order to use the chemical as you do to keep yourself. Yeah. Again, it's a conundrum, and again, I don't know if there's absolutely no clear answers to it right now. It is our opinion that the threat of the virus in itself constitutes physical loss or damage, and that's where and we have a pandemic, which is not specifically excluded under the policy forms of which we've seen. There's various other types of aspects of coverage in the policy that may provide coverage to help cover the expense of cleaning and mitigating as needed in order to protect yourself, because as I mentioned, you have a duty and obligation to mitigate. So if I didn't clean because I didn't have a confirmed case, am I susceptible to liability if anyone were to get sick? And then are they going to not cover me for that? You know?
Yeah. So, I mean, to just to finalize, I guess my answer here is there's not like a clear cut answer to your question, Jessica. So at the end of the day, I think what needs to happen is the board of directors gets together and they decide, because we already know that the CDC is requiring, you could call it minimal work. If you really wanted to just do household cleaning, you could do it. Again, following certain guidelines as to how to protect your employees. But we know that there's a minimum. So then the association needs to decide, okay, here's how we want to handle it. If we've got a confirmed case, this is what we want to do. You know, because at the end of the day, when they call us out there, we have to sit with the manager and say, okay, let's come up with a plan. When someone is confirmed, what do we do? What do we clean, et cetera? Or do you want us to come in once a week? Or, you know, are you waiting for this to all be over for us to come in and clean the entire facility? So yeah. It's just not that easy to answer.
No, I understand. So just to piggyback off of that, Catholic Group does have a template site response plan. So if anybody's interested in that, if you're self-managed and you know, maybe you don't have the guidance of a management company, or you feel that you would like more information, again, just email us info@catholicgroup.com. We'd be more than happy to share that with you. Catholic Group does have best practices around everything that we've talked about today, from, you know, how often we need to clean high traffic surface areas, what are those surface areas, and you know, companies that you can use, communication templates, all sorts of things, because it really is important to have a plan, just like Henry said. So I want to ask a question here regarding employees and vendors, right? So if an employee of a vendor for the association tests positive and has been on property, is that vendor responsible for cleaning, or is that the responsibility of the association? Does that vendor have any liability for putting the residents in danger?
Well, I believe that if a vendor's employee was or is infected and came onto the property, and now as a result of that, the association needs to or should clean out everything. You know, first of all, I think some vendors are doing the right thing, and some vendors may offer to pay. I don't know if there's an easy answer to this, Jessica, and I don't see, unless there's a contractual provision in the agreement with that vendor, obligating the vendor to pay for you know, any virus infestation caused by his or her employees to the condo association's facility. And I'd be shocked if any agreement you know, within a month or more any agreement that was executed within a month or more prior to this pandemic may have any of those provisions. You know, Dan has mentioned a few times that a lot of these insurance policies don't exclude or have language excluding pandemics. Well, there's a pretty good reason. You know, a lot of us really haven't been thinking about this over the last 10, 15, 20, 30, 40 years. And many of us haven't been putting those types of clauses into agreements. Yeah, you may find a lot of these, force majeure clauses and whatnot. And so now we start arguing the applicability of a lot of these provisions to the current affairs that we're all experiencing. But, it's going to be, I think, a case-by-case analysis to see what you can force your vendor to do. Otherwise, I think it's an association expense if you don't have clear language addressing it, or if you have a vendor that's not, as some of us might say, willing to do the right thing.
Interesting.
And to piggyback on what Roberto said, assuming that you do have the contractual language between the association and the vendor, the biggest question is if they're held legally liable or they were negligent, meaning them, the vendor, the easiest way for them to pay is their insurance, right? Their insurance policy. And the question then is, does their insurance policy contain any exclusionary wording for communicable disease or virus or pandemic or anything like that? Just like we're saying one of the hurdles for association is that second part, which is the exclusion. That holds true for vendors, contractors as well. So it's very important, that you do make sure and you do check. Yeah, I understand that during a pandemic like this, it's an emergency situation. You might not have the time to cross all your T's, dot all your I's, but it's a lot easier for the vendor to pay if there's insurance backing them.
Yeah, let me jump in there. I mean, being that myself or WRG and a couple of the other companies are used to handling so many of these high rises, we obviously have a pretty well thought out insurance program, and we have the appropriate insurances. But even like that, when this surged, when this COVID-19 emerged, we got a call from our carrier saying, hey, if you're going to be doing any of these cleanings, you need to have this. So it's something extra we had to purchase. I don't handle the insurance in the office, so I don't know exactly what the coverage is called, but they had us change our policy in some shape or form. So what I did want to say is I guarantee you that most of the companies out there offering these cleanings probably don't have coverage to do what they're doing. So for the associations, you definitely have to be careful and find out what it is they need to have on their policy and make sure that they do have it when you're checking those COIs.
That's great. Yeah, Henry, if you can follow up with me and send me that, because I'm sure I'm going to get questions regarding the exact name of the policy, but that's a great advice.
Okay, sounds good.
I think someone else wanted to say something.
Yeah, I was just going to say, and with WRG and Henry, when you're dealing with reputable companies like WRG, they get these calls from the carrier saying you need to endorse the policy to include A, B, and C. It's going to cost X amount. The reputable companies you'll see for the most part, they will add it or change their policy. But even reputable companies, sometimes they're saying, another six, and I don't know how much it is, but another 6 figures in premium. We're not, that's crazy. And then you have all these other remediation companies that don't do the same, or as far as not add the coverage. But the industry standard as far as making sure that these vendors and contractors have the proper insurance, it's a flawed system. So you need to make sure that you take a deeper dive to make sure that those endorsements that Henry added, making him eligible to work, and God forbid was negligent in any way, that you have the insurance carrier, whether it's he's dealing with AIG or Hartford or whoever it is, to back him up. God forbid there was an accident or an occurrence.
I just I just happened to look at an email from the agent. So it's called a disinfection endorsement.
Disinfection endorsement.
That's
Okay,
what
great.
Yeah.
Excellent. Okay, guys, so we have about 10 to 15 minutes left. So let's move on to some other hot topics here. So this is kind of our, I don't know, miscellaneous part of the discussion where we got a bunch of different questions from everyone regarding a bunch of different topics. So we're going to jump around a little bit over here, but I think it'll be fun nonetheless. So I'll start with my first one here. To what extent can a condominium restrict the residents from having people enter their building? Visitors, contractors, delivery people. I know we kind of went over that, but I don't know if anyone wants to take a deeper dive as to what they're seeing.
Well, you know, a lot of buildings that are doing this, to my knowledge, are relying a great extent on on what they perceive to be the emergency powers that you may find in the applicable statutes governing the community association. So let's take, for instance, the Condominium Act. You know, that one of the conditions is it requires a state of emergency to be entered. Well, you know, we checked that box off, you know, weeks ago. But then there are certain other elements, and there is amongst attorneys that do what we do. There is some debate as to the extent to which the emergency powers provided in the statutes do apply to this type of case, or was it intended to be more for a hurricane type property damage situation? And so now you've got that academic debate taking place. Nonetheless, you've got the division of the DBPR that came out and issued some type of administrative opinion to this. So we're kind of like walking around there and saying that statutorily we have the right to enact these types of restrictions within condominiums. And so now how far can we go? And I touched upon it earlier. You know, can you ban all guests from coming in? Can you ban the housekeeper for unit 608 to come into the unit? Or is that person allowed? How about the resident that has a nurse that comes and administers some type of treatment on occasion? Can that person come in? So you got to be mindful of a lot of these restrictions and the extent to which you're going to be more restrictive than you are putting a lot of faith in the emergency powers that the statutes may provide you, and the extent to which you are not as restrictive, then you know now you're going to be exposing yourself to claims that you didn't do enough. So you know it depends on which side of the argument you prefer to be on here, and so you know I think that discretionary things like vendors that aren't really necessary, but how about completing some plumbing work in a unit? How about changing out appliances that are necessary? AC units, do you require permits or not? I mean, these are all the types of issues that a lot of condos are having to grapple with right now, and they're interesting, but in many instances, I don't think anybody has the black and white correct answer.
Well, I have an attendee here who asked if, at the very least, can they at least enforce everyone to use masks, right? If you do have to have people entering the building, can they enforce that?
You know, you can ask for it, but how are you going to force anyone to wear a mask? You know, as a condo, remember, condo associations aren't police authorities. Yeah, they've got the power to impose de facto taxes that we refer to as assessments, you know, but they don't have any real teeth to force somebody to wear a mask, any more so than they have any real teeth to force an infected person to stay in quarantine. And so what can you do? Well, yeah, of course, you can suspend the use rights in common elements if you convene a committee meeting or a fining suspension hearing, but are you really going to do that nowadays? A 14-day notice requirement for that? Are you going to call the police? You know, I've had a lot of associations call the police and the health department, and they basically get an answer of saying, you know, thank you very much for calling us. You know, we'll add it to our list. We'll get to it when we get to it. Some police say we don't have the power to do anything. That's a private dispute between civil, between residents and a condo association. So we are in a very in a state of uncharted waters for these types of issues and associations. Unfortunately, if residents don't take it upon themselves to do the right thing, associations unfortunately are very limited as to what they can force people to do.
Wow. And what about short-term rentals and longer-term rentals? Like what can they do with that? I mean, is there, like, I know you're saying that there's not much enforcement, but can they mitigate that in any way?
Well, a lot of associations have taken it upon themselves to just prevent any new tenancies or new applications from coming in. Short-term rentals have been very difficult traditionally to police and monitor. At least in this situation, we've got associations that are acting a bit more aggressively and taking the steps to prevent it, because you don't have the ability to screen or to even determine who's coming into the building from a health perspective. Traditionally it's because we don't know what their background is. Are they people with a greater propensity to disturb our residents, or are they or not? In this case, yeah, we still have to deal with that type of an inquiry, but yeah, they also may have come from some place with a high concentration of community spread of this virus. So associations feel justified in preventing those short-term rentals and transient occupancy. But again, it depends on what type of setup you have as an association. If you don't really have a lot of control over the ingress and egress of people, if your garages, if your gates, if your entry and exit points are not highly controlled, how is an association realistically going to monitor that? So you got to look at how your association and condominium are set up before you can answer how you can regulate those short-term rentals.
Okay, so let's take a question here from one of the attendees. This is regarding their on-site cafe. It is offering deliveries and they're providing a great service, but they're concerned that they might open themselves to liability if one of the employees contacts the virus. They're trying to be diligent, they're wearing masks, things like that. But do you think that it's a good idea to keep the cafe open, or should they close that down?
I'll take a stab at this one. So I personally think, and it's the position of a lot of attorneys, and Roberto can opine on that after, but try to minimize your exposure as much as possible. If you have an amenity, an additional amenity to, we understand it's tough times right now for unit owners, and we want to make the experience as pleasurable as possible. I know that I'm a board member myself of a large condo in Aventura, and I know that it was kicked around a few times to add some amenities there, or at least to make life easier. But I would try to stay away from, having that human to human interaction. I understand that you have masks. I understand you might have gloves, but that's our recommendation.
I would agree.
I have another question here. Are carriers giving leniency for payments, and do you think that premiums will go up due to COVID-19 in the future?
Okay, so two very different questions. So as far as leniency on you said on premium payments?
Mm-hmm.
Okay, so yeah, we have had some communication. For example, one of the communications, and I have it here on my desk, but it's, FEMA's come out for flood insurance. FEMA's come out and the typical 30-day grace period, which FEMA's always given, they put out communication that now they're going to give a 100 grace period. I would caution associations from exercising the grace period, because without the funds or the premium for flood policy, we as insurance brokers cannot secure the declaration page of the flood policy, and in turn we cannot issue them to the lenders. And what happens is, if your lender is not flexible, which they should be, but if they're not flexible, there's a chance that they could force place coverage. And it's a nightmare for unit owners. It's a nightmare for the management company. So that's one communication. There are other direct insurance carriers, for example, Zurich and Travelers. So some of them have issued statements where they can defer payments or work with the insured as far as leniency on the timing of the payments. The problem is that condominium associations, typically the policies that they purchase, the money's due up front, so you're not paying the installments to the carrier. You're paying the installments to the finance company. So it's not about the carriers being lenient, because they're already paid up front. It's the finance company. And what was your second question?
If insurance premiums are likely to go up because of the pandemic.
So that's a very interesting question. So prior to the pandemic, we still are experiencing a hardening market, and it's for various reasons. But the global losses are a contributor. In turn, the reinsurance treaties are a contributor. But when this pandemic broke and came to light, we actually didn't see a knee-jerk reaction by carriers. We didn't see a knee-jerk reaction, and we're still right now in the infant stages of COVID-19. And I believe we mentioned this before, is the case law is really what's going to shape the history of COVID-19 and how it affects future insurance and future renewals. If carriers are forced to pay, and the biggest exposure, and Dan mentioned this earlier, the lawsuits that have been filed so far are the restaurants and the businesses for business income, loss of business income. And if these carriers are forced to pay the business income claims, which you've seen in Ohio and Louisiana and New York and most recently Pennsylvania, you're going to see premiums increase. If they're forced to pay these business income claims, you will see premiums increase. Reinsurance is going to be triggered. Okay, when reinsurance is triggered, meaning they're going to pay, just like last year, reinsurance rates are going to skyrocket. So it's too early to tell. It's really going to depend on the case law, and we're actually sitting through, the history is being written. And I understand Zika, we saw that, but we're going to see how this plays out for future renewals.
I think a lot of people are concerned about making claims because they think that by making a claim, their rates go up. History has shown that there's more correlation between the market conditions and their rates than their history, their loss history. And obviously there's outliers, there's extreme situations where you have an association that has a habit of filing, 10, 20 water losses a month or so. Obviously that's just a bad transaction and a bad deal for an insurance company. We saw during the softer market where we collected tens of millions of dollars for a single association and get a renewal at a reduced rate, and sometimes even a 18 to 24 month deal. So I've heard from, and I've actually seen in writing from a number of brokers to business owners, particularly dissuading their insurers from making claims because they're headed into a renewal or in the midst of a renewal or something, and how that somehow is going to prejudice them or cause their rates to go up or some other, what I would consider to be nonsense and loosely based on actual facts. Because what has really driven rates are market conditions. Ironically, though, we were in one of the best economic positions in the beginning of this year, despite the hard market. It really wasn't adding up. There was actually questions regarding the requests for increases and the validity of those requests. Certainly, since the insurance company came out so hard and fast and said none of these claims are covered, you would expect that the rates to be unaffected by this whole COVID issue. However, also insurance is done based on pooling of risk. And so if the pool is much smaller, then we all must share more of that risk. And therefore you have a direct correlation between that increase and premium. So those are some technical factors that may result in rate increases, even if there is no coverage for these claims. The pool for insurers is smaller because you have so many business out of business to enable the insurer to spread its risk. So again, the insurance is a very complicated matter, and there's no direct correlation and easy response or answer to, do my rates go up if I file claims, or do I get dropped, or things like that. Those that are providing direct answers and saying, yes, there is, are misleading their clients or consumers. And we see it all the time, because I can point to many, many situations where we saw dramatic rate reductions, if not flat renewals, after significant recoveries for policyholders and many community associations.
Right.
Wow.
And to Dan's point, the market is the key driver of, the increase or decrease that an association is going to experience. And for the past, 5-6 years, we were in a soft market, but then we actually had a Category 5 storm in each of the last 4 years. But global losses also are a contributor. But I actually read something a day or two ago, and I pulled it for this webinar. But the American Property Casualty Insurance Association, so they're now estimating that the closure losses, so the business income losses for just small businesses with 100 employees or fewer, is estimated at $431 billion per month. And what they're saying is that these numbers dwarf the annual premiums for all property, commercial property risk. So if the premium that they're collecting, the $431 billion per month, dwarfs those premium that are collected, that could potentially change the shape and the market, and potentially expedite this hard market. But again, it's too early to tell. We have to see how this plays out.
Thank you. So let's move on to our questions and answers segment. We've done a good job at answering a lot of these questions as we've been going, but for those of you who are still on, this is your opportunity to submit them. I have a couple here. I heard that there's some additional insurance that you can get for legal defense. I mean, can you expand on that?
Sure. Yeah, so there's a unique policy out there for legal defense. Actually, there's a couple different variations of it, but the premise is we talked about your third-party coverage and your liability or your D&O, and you have exclusions in there. And the premise of these unique policies, if coverage is not afforded by the carrier, meaning there's an exclusion, these policies have wording that say we don't have a duty to defend. The overwhelming majority say we don't have a duty to defend. So if coverage is excluded because you received a lawsuit, and your typical GL policy or your D&O will not cover it. So this unique policy, what it does is if you do receive a declination from your carriers, it would trigger that coverage and afford you the defense. It's not an indemnity type of, it's not going to pay for settlements or judgments, but it's a legal defense type of policy. So they're fairly new. They're a couple years old. There's different variations of them, like I said. So we can provide more information if anybody just emails me, and we can provide that information for you.
Excellent. Thank you so much. That's good to know. Okay, and I have one more here. The rest we'll just have to follow up with you later. But what happens if there's a water or fire emergency during our current circumstances? What do you do? What do you suggest? I'm
actually going through one right now, and I'm going to have Dan piggyback on this because I see he's itching to, I'm actually going through one of these right now where not only do we have a confirmed case, but we do have a significant water damage loss. And, you know, it's unfortunately business as usual. You have a duty to mitigate those losses. And if it's a water damage loss or a fire loss, you have a duty to mitigate so you don't, so further, you know, future damage or more significant damage doesn't occur. And whether that's hiring Henry's company, Water Restoration Group, coming in and mitigating the issue, there has to be some additional protocols in place to make sure, especially, you know, in this particular situation, there's a confirmed case. So, but you do have to continue, just as if there were no COVID, as far as filing the claim and going through the motions with the property adjuster to make sure that situation is mitigated.
Excellent.
Yeah, I think adding to that, you know, there's going to be some question relating to the additional steps that you took to protect that property and whether or not there's coverage for it and how that's classified or documented by Water Restoration Group or a contractor similar to that. For instance, the protective gear that they're wearing, the additional steps to clean the area as they left it, as they make their way through the common areas into units, accessing their trucks inside the garage areas, things like that. Because if they do have to access a unit where a unit owner is a confirmed case or a carrier of the virus, or maybe like as Henry mentioned before, maybe you don't even know. You have no choice but to take preventative measures in order to not only protect the property, mitigate your damage from the water damage, but also protect the property and mitigate your damage related to this pandemic issue. So, you know, making sure that you include that scope of work in there, whatever's necessary, and not parse it out is going to be helpful in your claims process. Because the more you delineate between the two, the more the insurance company is going to argue that there's something separate or different or apart and try to prejudice you by mitigating the coverage for those issues. Similar to if you have a water loss, you're always preventing or taking steps to mitigate the potential exposure to mold or the spread of any type of mold or bacteria. It's no different and should be covered under that single limit for water damage as well. Should may not be something separate, despite the desires of insurance companies at times to parse these things out and subject you to lower limits or exclude coverage altogether. It's important that you don't succumb to those pressures and that you do advocate for your rights and understand how in which that documentation needs to be issued and submitted, and making sure your contractor is properly documenting those efforts as related to the actual covered loss, which is the whole reason why they were there to begin with, which was a water loss.
Great. Thank you. Thank you so much. So we have about 2 minutes left here. So I want to give a special thanks to our partners. And at this point, do you want to offer any closing remarks before we end the webinar? Not all at once, please.
I want to thank Castle Group and all of the esteemed panelists that I get to enjoy this with. I know, like them, we're always available for questions and comments and important feedback. We want to be a resource to boards and property managers alike. So I know that Global Pro stands ready to respond when needed.
Same here. Thank you to Castle Group and to all the panelists, and we are always here to answer any questions. It won't cost you to call and ask.
Yeah, I want to echo those comments and statements, and also appreciate Castle for the invite, as well as the participants for their insightful questions. I also want to part by saying that, you know, much as society is doing, we all got to do our own part. Residents, owners, lawyers, managers, insurance agents, etc., you name it, but everybody's answering the call to inform people as much as possible. These are unprecedented times, to say the least, and obviously we're going to get through this. We're going to get to the other side and have a lot to learn from. But you know, patience and doing the right thing, I think, is what we all need right now. Level heads.
Stay healthy.
And healthy. Yes. So thank you everybody for joining. Castle, big thank you for inviting, and all the panelists. Appreciate working with you. It was a pleasure. Willis Towers Watson is here if you need us, whether it's our global coverage review team to interpret the policies, to tell you the potential hurdles that you may have, whether it's the legal defense or the contractors coming onto the property. We're a one-stop consulting firm. So thank you again to Castle and all the panelists and all the attendees.
Thank you guys, appreciate it. Again, if anyone has any further questions, if you want to get connected with our panelists, email us at info@castlegroup.com. You can follow us on LinkedIn, Instagram, or Facebook, where you'll find a lot of resources and information, as well as promotions on our webinars. We're having webinars almost every day in all of our different markets throughout the state and in Texas. So please do not hesitate to reach out to us. Thank you again for attending, and we'll see you soon. Have a good one.
Bye-bye.